UGC. Our university has organized this workshop, and we are joined by Professor R.P. Dubeji, Vice Chancellor, Dr. C.V. Raman University, respected Shri Gaurav Shuklaji, Registrar, Dr. C.V. Raman University, Professor Jayati Mitra Madam, Pro Vice Chancellor, Dr. C.V. Raman University, Shri Shibrat Sahuji, Examiner of Patent and Design, Indian Patent Office, Delhi, Ministry of Commerce and Industry, Government of India, Shri Abhash Kumar Bhoiji, Examiner of Patent and Design, Indian Patent Office, Delhi, Ministry of Commerce and Industry, Government of India. Likewise, Dr. Arvind Tiwari, Dean Academics, Dr. Manish Upadhyay, convener of this workshop, and also joined by Dr. Anupam Tiwari, organizing secretary of this workshop. Today we are gathering around 500 participants in this platform throughout the country. I would like to welcome all of you to this workshop. Very welcome to all of you. On behalf of CVRU, we welcome each of one of today's workshop who are attending this workshop. We welcome all the viewers, listeners of this workshop through the broadcast. The theme of today's workshop is very important because it deals with the very vital issues related to the country. So, in the intellectual property rights, that on the behalf of CVRU team, I'm very welcome to all of you. And firstly, I would like to invite Shri Gaurav Shuklaji to come here and welcome to each and everyone's here. Shri Gaurav Shuklaji.
Thank you, Jyoti ma'am. Azadi Ka Amrit Mahotsav, a workshop on IPR awareness under the National Intellectual Property Awareness Mission, organized by Dr. C.V. Raman University and Government of India, Ministry of Commerce and Industry. I welcome as a Professor R.P. Dubey, Vice Chancellor Dr. C.V. Raman University, who will preside over the this program, and our two experts from the Government of India, Ministry of Commerce and Industry, Subrat Sahuji and Abhas Kumar Bhoiji. I welcome both of them from Dr. C.V. Raman University. And in today's program, we have Professor Manish Upadhyay sir, as a convener of this program. We have Professor Jayati Mitra, Pro Vice Chancellor, Dr. C.V. Raman University, Professor Arvind Kumar Tiwari ji, Dean Academic, and Professor Anupam Tiwari, co-convener of this program. I welcome all of you in this IPR awareness program. As you all know that Dr. C.V. Raman University is established in 2006 in the tribal belt of Chhattisgarh, and the idea of establishing C.V. Raman University in this tribal belt is to provide the higher education, give the facility of higher education, world-class facility to the tribal belt of Chhattisgarh, where the higher education was very rare. And we are spread over 70 acres, and we have our own Radio Raman 90.4 established here in the campus. We are also a skill partner of Government of India. We have PMKK, Pradhan Mantri Kausal Kendra, in the campus as well. We are NEC B plus university, and we are also once in 2070 our NIRF ranked institution as well. Our idea is to now these days after the COVID, as the COVID era is difficult era for everyone. We have also faced a lot of problem, but now the things are coming into the normal situation. We wanted this program to be offline, but still there is a problem is going on, so we have organized in the online fashion. But as you know that right now we are focusing our mainly to the research area. We have more than 70 patent in the name of Dr. C.V. Raman University, which is a great achievement in this last 3 years we have achieved through our faculty and our scholars. We are promoting research in the field of cultural, in the field of local cultural, Chhattisgarhi culture, and also in the field of science. And I really thank Subrat Sahu sir जो कि उन्होंने यहाँ पे सीवी रमन यूनिवर्सिटी में ये प्रोग्राम जो है ऑर्गेनाइज हमें यहाँ पे कराया. We are also in talk with the Kalinga University at Bhubaneswar for the patent which has been registered under the CV Raman University, how to commercialize the those IP patent, and how what are the utilization of that patent will be. So we are very soon we will have a MOU with Kalinga University as well. So I thank all of the government of India, particularly South sir, choosing Dr. C.V. Raman University for this awareness program. Thank you very well. Thank you very much, sir, and I welcome all our speakers in this program. Thank you.
Thank you so much, sir, for your welcome speech. So IPR is very important in the present time because nowadays the importance of trademarks, the importance of patents, importance of copyrights and other intellectual rights has main significant momentum, and it has one of the parameters which have also reflect an image of any country and also reflection of country's knowledge pool or intellectual pool. So to know more about that, I would like to call upon Subrat Sahuji. So please, over to you, sir.
Thank you, ma'am. Thank you very much. Before starting this session, let me first say very thank to everyone for joining this session. So it's about the awareness of the intellectual property. See, this is the under the aegis of Ministry of Commerce and Industry. The National Intellectual Property Awareness Mission was started in December 2021. Our Honorable Minister, Mr. Piyush Goyal ji, he has inaugurated the session with a vision under the Azadi Ka Amrit Mahotsav. We need to create an such kind of environment so that each research scholar, each student, every field, everywhere throughout the India, they must be aware how to file an patent, how to file a design, how to file a trademark, how to file a copyright. See, we know we are running in the 21st century. This is the knowledge driven economy. To make our economy 5 trillion, we must meet every aspect of knowledge. And to meet this aspect of knowledge, we need to create a wealth out of that particular knowledge. So, how to create a wealth? Until and unless we are not transforming our knowledge to a wealth, then it is of no value. So, under that thinking, under that particular invention, under that particular perspective, we have just started the NIPAM. So our ministry have already stated each and every institute, it may be a state university, it may be a private institute, it may be a national institute of importance, whether it may be situated in any corner or any part of India, we must reach there. And we must acknowledge them. See, whatever the resources you people have, whatever the knowledge you people have, you must protect it. Until and unless you are not protecting your knowledge, then somebody else will come and they will infringe you. So that's the most important what we call the main motive of this awareness program. So in this awareness program, we are not only we are going to aware you what are the IPR, we are also going to teach you how to create a patent out of your knowledge, how to just create a trademark out of your invention, then how to file that particular invention in the Indian Patent Office or Indian Trademark Office. So for that particular session, we have designed in two different perspectives. First of all, my colleague, Mr. Abbas Kumar Bhoi, he will guide you and he will tell you what are the different perspective of IPR. What are the IPR? What are the patent? What are trademark? What are the copyright? And what are the all the geographical indication? So, what are the main aspect of the IPR, the intellectual property? He will guide you, and he will come to come to the strength and come to make you know what are the this kind of things you must need to know. And the second in the second session, I will go through you then what is the actual filing procedure to grant a patent in Indian Patent Office, and in which way you need to write a patent. See, it's all about designing a draft, designing a specification, designing a application. So the way you are designing an application, it's up to you how your examiner and your controller you grant you a patent. So I will let you know how to design and patent application, how to draft your idea, how to draft your invention in the second part. So without just spending much time, let me say again thank you CV Raman University for accepting us. And it's not a one way process, it's a two-way process. Not only we'll aware, we also ask and we also encourage our student as well as our all the faculty member research scholar, so that what will happen, their knowledge become a part of the wealth creation, and they become a part in the wealth creation of throughout the India. So it's all about that mission. So I will now ask Mr. Abbas Kumar Bhoi, kindly just tell about what are the different perspective of IPR and what are the IPR, and how we just go through about different aspect during the writing of any particular invention or during the research work, how to create that kind of IPR, that kind of patent or trademark. He will get let you go. Okay, thank you.
Let me share my slide. Okay. Hello everyone. So this is IPAR awareness program under National Intellectual Property Awareness Mission, and I will be talking about the importance of intellectual property right and its prospects. So before discussing what is intellectual property rights, let's see what are different kind of properties. Property is generally classified into tangible properties and intangible properties. Like tangible properties are the property which can be physically touched, which can be physically seen, and it is further classified into movable tangible property, for example, car, and immovable tangible property, which is building. And intangible properties, actually, this is the property of human intellect, and which comes under the intellectual property. This intellectual property, further, it is comprising of industrial property and copyright related properties. And this industrial property further comprises of patents, designs, trademarks, geographical indication, etc. So from this, it is clear that intellectual property is generally composed of patents, designs, trademark, geographical indication, and copyright related properties. Now, what is an intellectual property? The intellectual property, it can be a design, it can be a idea, it can be an invention, it can be a manuscript, which can ultimately give rise to a useful product and application. Suppose any inventor who has any design, a idea, an invention in his mind, and that particular idea, design, or invention that is ultimately giving rise to an useful product and application, that can be termed as an intellectual property. It's a property of human intellect. It's a property resultant from human mind. And this intellectual property, uh, that can be protected through intellectual property right. So intellectual property rights are the right of an inventor to derive economic benefits from his intellectual property. And suppose, let's see one example. Uh, a pharmaceutical company develops a antiviral drug for the COVID, and he has patented that particular the drug that he has developed. फिर उससे क्या कर सकता है कि मान लीजिए वो जैसे उसने जो भी इंटेलेक्चुअल प्रॉपर्टी राइट्स उसमें है उसने उसको प्रोटेक्ट कर लिया, तो वो क्या कर सकता है, उसको कमर्शलाइज कर सकता है मार्केट में वो कमर्शलाइज करके राइट ऑफ एक्सक्लूजन रहेगा उसके पास, राइट ऑफ मोनोपोली रहेगा, एंड एंड बाय कमर्शलाइजिंग दैट ही विल अर्न and he will get economical benefit out of it. So that is very important. If you have any intellectual property, you must protect it to derive economic benefit. So it's a right, intellectual property right means it's a right that is granted to the inventor to derive economical benefit, and it's an exclusive right for it, and the right is given exclusively to the inventor. And now, what are the objective of granting an IPR? Let's see. It generally enhance the performance level of institution. Generally, in institution, we do lot of research, we publish papers, but generally we do not go for patenting. And when when we go for पेटेंटिंग करने से क्या होगा, मान लीजिए जो भी इंटेलेक्चुअल प्रॉपर्टी आपकी इन्वेंशन में है, आप उसको प्रोटेक्ट कर रहे हैं, you will have an exclusive right, you can commercialize it, and you get an economic benefit out of it. So it gives recognition as well as financial benefits to the efforts for the creativity of the inventor. Now, because of that, it will create competition among the researchers and institutions for quality of research, and to fasten the technology transfer through licensing and other means. And what is licensing here? I will discuss. Suppose a company, a pharmaceutical company A, is preparing an anti-cancer drug for treatment of cancer. Now, another similar pharmaceutical company working in the same field, वो क्या चाहता है कि वो भी जो भी एंटी कैंसर ड्रग जो कंपनी ए मार्केट में कमर्शलाइज कर रहा है, उससे अर्न कर रहा है, वो भी उससे सेम प्रोडक्ट को मार्केट में कमर्शलाइज करना चाहता है. Then he will get a license from that parent company A, and through that he will have to pay royalty to that parent company who has developed that anti-cancer drug. Now, the company B, who has obtained the license from company A, he can also commercialize that anti-cancer drug and can earn also. And by protecting intellectual property, there will be more creation and invention, which will ultimately benefit the society. Okay. So we have seen that intellectual property composed of patents, designs, trademarks, geographical indications, copyrights, semiconductor integrated circuit layout designs, protection of plant varieties and farmers' right, and trade secret. Before moving to what are the intellectual property rights? Let's see here one example. The different intellectual properties that are involved in this single product. Here we can see ये एक एप्पल का मैकबुक है जिसमें कि जो एलईडी डिस्प्ले है, जो एलईडी डिस्प्ले में जो टेक्नोलॉजी इन्वॉल्व होता है, यू कैन द टेक्नोलॉजी कैन बी पेटेंटेड, you can protect that technology through patent, and the design, the shape of the display, and the color and
आवाज सर आवाज नहीं आ रही है.
is there any problem?
हाँ अभी इसमें आ रही है प्रेजेंट.
Am I audible?
Yes sir, yes sir.
Okay.
Yes, sir, you're audible, sir.
Sir, you need to share your screen
Continue.
again, sir.
Okay. Okay, let's continue. So, intellectual property basically involves the human intellect of an inventor. Through human intellect, a research person will use the resources available to him, and he will do research, he will do experiment, and use his labor to create any invention. At that invention, the intellectual property involved in that invention that can be protected through intellectual property rights. And the importance and significance, if we look at by protecting intellectual property through intellectual property right, basically it excludes others that I have already discussed. Suppose a company commercialize any antiviral drug, and he has obtained any he has protected the invention through intellectual property rights. Suppose he has obtained any patent regarding the antiviral drug and the process, then he will exclude the similar company who are also working in the same field, preparing antiviral drug, and by thus he will get a monopoly. He will commercialize in the market. He will get a right of exclusion, and because of that he will earn, and he will there will be obviously advantages by protecting intellectual property. And the difference between common person and businessman, if you see, a businessman, what he does actually, when there is an invention, he will first protect उसमें जो भी इन्वेंशन में जितने भी इंटेलेक्चुअल प्रॉपर्टीज इन्वॉल्व हैं, जितने भी इंटेलेक्चुअल प्रॉपर्टी राइट्स, first he will protect those, then he will commercialize and he will exclude other by protecting his intellectual properties. He will exclude others, and thus he will create a brand value, and he will earn, and he will develop and growth. There will be growth in the business. Okay. In common person, what generally what happens in academics or institution level, we do a lot of research and we publish paper, but we generally do not go for patenting, and we we do not get any right to right of exclusion, or we cannot derive any economical uh, benefit out of it when we do not protect any intellectual properties. So there is certainly more advantages if we protect intellectual properties. Now let's discuss what are patents. A patent is a right that is granted by government to an inventor to exclude others from imitating, manufacturing, using, selling the invention in question for commercial use during the specific period. So I have already explained that and suppose any pharmaceutical company, he has obtained a product patent, then he will exclude any other pharmaceutical companies from making that product or selling that product, and this right he will enjoy. ये जो राइट थ्रू पेटेंट मिलता है वो एंजॉय करता थ्रू टू सम स्पेसिफिक पीरियड. पेटेंट कोई कभी भी अनलिमिटेड ड्यूरेशन के लिए नहीं होता है. ड्यूरिंग दैट स्पेसिफिक पीरियड ही विल एंजॉय द राइट ऑफ एक्सक्लूजन, he will commercialize the product, and he will earn. Okay. And generally patents are granted for an invention. An invention can include any product. Okay. And innovation and improvement in an invention. Suppose a anti-cancer drug is already available and already that is patented by any company, and और एक कंपनी क्या करता है, उस एंटी कैंसर ड्रग को मॉडिफाई करता है थ्रू एक्सपेरिमेंट एंड थ्रू रिसर्च. ही चेंजेस द फंक्शनल ग्रुप्स ऑफ द ड्रग, और उससे क्या होता है कि बिकॉज ऑफ दैट उससे उसको बायोलॉजिकल रिस्पॉन्स टाइम ज़्यादा मिलता है. जो कैंसर ट्रीटमेंट, जो कैंसर पेशेंट है वो जल्दी रिकवर कर रहे हैं. देयर इज एन इम्प्रूवमेंट ओवर एन इन्वेंशन, and because of that there will be economical significance and technological advancement in that invention, and that can be also protected through patents. And process and product of an invention can also be protected through patents. The process for making any drug molecule, either it can be any anti-cancer or antiviral drug, that process can be patented, and the product that can also be patented. Now, patent is granted by a sovereign or state to a person that is giving exclusive right to stop others from making, using, exercising, and importing. So it gives an exclusive right to the inventor, and it gives a right to exclude others from using your invention. And there is a limitation to a patent. There is limitation of time and limitation of space. लिमिटेशन ऑफ टाइम क्या होता है, पेटेंट कभी भी अनलिमिटेड ड्यूरेशन के लिए तो ग्रांट नहीं होता है. इट इज ग्रांटेड फॉर स्पेसिफिक ड्यूरेशन, दैट इज इट्स वैलिड फॉर 20 years. तो ड्यूरिंग दैट 20 years, जैसे 20 years काउंट होता है डेट ऑफ फाइलिंग से, तो ड्यूरिंग दैट 20 years द इन्वेंटर can enjoy the benefits. He gets the right of exclusion. He get the rights of monopoly right. Okay, and another is limitation of space. Limitation of space means a patent is valid only within the territory of the country in which it is filed. Suppose a patent is filed in India, then and it is granted in India, then that patent will be valid will be within the territory of the India. Outside the territory of the India, it will not be valid. Okay, so there will be limitation of time and limitation of space in patent. And what are the chief requirement for granting a patent? Suppose you do an invention, okay, and by how that invention can be protected through patent, the chief main requirement will be novelty, inventiveness, industrial applicability, and patentability. It must pass all these chief requirement. So what is novelty? Novelty means it must be new and should not be already known to the public. It should not be uh, that should not be disclosed in public domain. Suppose that particular antiviral drug, it should be new. It should not be already present in the market. Then it will pass the novelty criteria. And inventiveness. In inventiveness, we have to see the. It should not be obvious to a person skilled in the art. It means when you are doing an invention, it must have economical significance and technological advancement over the invention. जैसे कि ऑलरेडी आप एंटीवायरल ड्रग प्रेजेंट है, आप कोई इन्वेंशन कर रहे हैं, कोई उसको मॉडिफाई करके आप रिसर्च करके और एक एंटीवायरल ड्रग उसका सिमिलर बना रहे हैं मॉडिफाई करके, और उस ड्रग से आपको इकोनॉमिकल बेनिफिट मिल रहा है, इकोनॉमिकल सिग्निफिकेंस मिल रहा है और टेक्नोलॉजिकल एडवांसमेंट है, देन इट पासेस द इन्वेंटिव स्टेज. एंड द थर्ड वन इज इंडस्ट्रियल एप्लीकेशन एंड यूजफुलनेस. जो भी इन्वेंशन आप कर रहे हैं, दैट मस्ट बी यूज्ड इन इंडस्ट्री एंड दैट कैन बी प्रोड्यूस्ड इन द इंडस्ट्री. एंड fourth one is patentability. Suppose you do an invention and it passes all the three criteria: novelty, step, inventiveness, and industrial applicability. But the most important thing is that it must passes the patentable criteria. तो पेटेंटेबिलिटी क्या होता है? जो इंडियन पेटेंट एक्ट में, इंडियन पेटेंट एक्ट 1970 में सेक्शन 3, जो भी इन्वेंशन आप कर रहे हैं अगर उसके अंदर फॉल करता है, सेक्शन 3 के अंदर फॉल कर रहा है, तो वो पेटेंटेबल नहीं होता है, पेटेंटेबल इन्वेंशन नहीं होता है. देन द सब्जेक्ट मैटर ऑफ पेटेंट मस्ट बी पेटेंटेबल अंडर द एग्जिस्टिंग लॉ एंड इट्स करेंट इंटरप्रिटेशन. और पहले जो इंडियन एक्ट 1970 था, वो प्रोडक्ट पेटेंट्स इन फार्मास्यूटिकल, फूड्स एंड एग्रोकेमिकल में अलाउ नहीं करते थे. नाउ इट हैज़ बीन अमेंडेड एज इंडियन पेटेंट अमेंडमेंट एक्ट इन 1999, and this new act allows product patents except for some specified medicine drug. Now let's see some real life examples. Here the baby shower head, the design and the material that is used, that can be protected through patent. A projector that is present in a wristband, this technology can be protected through patents. And the technology involved in drone that how much altitude it will fly, the positioning of camera, the positioning of the blades, and this technology can be protected through patent. Now और एक जो एक और एक इंस्ट्रूमेंट है जो कि आप मोबाइल में आप लगा सकते हैं. मोबाइल में लगा के कोई भी क्रेडिट कार्ड या डेबिट कार्ड का आप अकाउंट डिटेल्स उससे आप पता कर सकते हैं. दैट टेक्नोलॉजी कैन बी ऑल्सो प्रोटेक्टेड थ्रू पेटेंट. एंड द सैमसंग जेड फोल्ड सीरीज फोन, द टेक्नोलॉजी दैट इज इन्वॉल्व इन द flip phones and foldable phones, that are also protected through patents. So basically the technology that are protected here, and the it gives a it gives the inventor an right of exclusion, and it gives the inventor a right of monopoly to commercialize that product in the market, and he can earn out of it. Now let's see top trending 20 invention that we should not live without.
Hey, what is going on, everybody? Aaron here,
That's
and
what.
welcome back, or welcome to Top Trending if you're new. Today, what we're bringing you guys is 20 of the most.
Is there any problem?
Sir, your screen has been minimized.
Okay, okay. And my voice is audible throughout this
Yes, sir, it is
presentation?
audible, sir. It is audible.
Okay, okay.
Sir, if possible, kindly bring it in full screen mode.
Yeah, yeah, yeah. I'm doing that.
Yes.
Now it is full screen.
No, sir, yet not. You need to share the screen once again, I think.
Yeah, I already did.
You need to share your screen once again, sir.
Yeah.
I think some technical glitches are
Now
there.
is it full screen?
No, sir, yet not.
There may be some technical issue.
I think you need to close it and share it once again.
Full screen.
Yes. Sure.
Is it visible? Is it full screen?
No, sir. Yes, sir.
Okay.
Sir, just 1 minute, sir. Just 1 minute, it will be
Yes.
uploaded. Yes, it's right. It's okay right now. Please, please.
Okay. Okay. So let's continue. So let's see top trending 20 invention, and we shouldn't live without. Let's see one video here.
Hey, what is going on, everybody? Aaron here, and welcome back, or welcome to Top Trending if you're new. Today, what we're bringing you guys is 20 of the most unknown and most useful inventions that you probably didn't know existed. Probably going to make you go to either eBay or Amazon, possibly purchase some of these yourself. So go and sit back, relax, and enjoy the video. These LED traffic lights are the way of the future. You can see the time tick down into the different color lights. Less accidents, less stress, and a whole new, better way to drive. We have the ironing board mirror, which basically, like the name says, you can iron on the ironing board, flip the board over, and voila! You have a mirror where you can look at your sexy self in. Tired of not being able to sit on the bench after a rainstorm? Then this invention is just for you. Simply crank the bench to a dry spot, and then you have a nice place to put your butt. Can't find that wrapping paper that you need that you've been searching everywhere for? Try this Word Search Universal Wrapping Paper. Simply circle the word of the event and you're done. Great for birthdays, Christmas, anniversaries, graduation, and much, much more. Picture this. It's Monday morning, you're tired, and it's raining outside. How are you going to hold your coffee and the umbrella at the same time? Introducing the cup holder umbrella, where it only takes one hand for both items. Don't you just love one-hand multitasking? So you can't seem to get all the toothpaste out of the tube. Hands not strong enough for that? Then get yourself one of these fancy tube squeezers and say goodbye to countless hours of bad breath. Do you love babies and scooters? Then why not get this hybrid of a stroller and a scooter? Just simply place that little bundle of joy in the seat and away you go. Foggy mirrors are the worst. It happens to all of us. We get out of the shower and can't see what we're doing with the mirror. Have no fear, the mirror wiper is here. With his handy dandy suction cup, it's easy as 1, 2, 3. No more using your prudy hands. Don't you just hate when your outlets go to waste when you can't fit that one plug or charger because the others are in the way? Then this is the product for you. Simply attach all the Lego pieces and rotate them to your liking. Fit way more than you ever would before. Oh, just one thing. Don't misplace them because everyone knows there's nothing worse than stepping on Legos. Want a quick squirt of your favorite fruit juice? Then stick this spray spout in your grapefruit, orange, or tangerine and enjoy the citrusy goodness. Pizza cutters are the thing of the past when you have pizza scissors. What makes this even better is that you can cut, grab, and place the pizza with one movement of your arm. Introducing the Cat Table, the table that allows your cats to play while you work. Equipped with many fun routes for your cats to take, they won't have to be jumping all over you anymore. Some people slurp and others twirl. If you're a twirler, then this is the invention for you. The curved barbs on this specially designed twirl fork will make it easier for the spaghetti to stay on the fork and you can actually enjoy your meal rather than struggle to eat it. The cat crib will give your little feline friend an extra place to sleep that doesn't involve on top or around you. Take the extra precautions and make sure no one ever uses your coffee mug without permission again. This one has a key that you must use to unlock the mug. No key, no entrance, no coffee. This holder will make cutting fruits or vegetables a snap. No more chopped fingers and other strange injuries. If you decide to cut onions, you will most likely still cry. Onion cry guard sold separately. Do you want to be the life of the party, or even a master bartender? Then buy the Ring Thing bottle opener. Simply place in your finger and open bottles like you never have before. Do you hate carrying around an umbrella but don't want to get wet? Then call right now to receive this inside-out retractable umbrella. Simply pull down and it's no longer a burden to carry. Do you want to be more healthy and just eat egg whites? Then pick up this gulping yolkfish egg separator at a store near you. You'll be on your road to strong bones in no time. Do you hate seeing nice candles go to waste? Do you want to use them 100 times over? Then get the wax recycling candlestick. The candle burns and the wax melts down to create another candle. Now that's what I call eco-friendly. Alrighty guys, and that is going to do it for today's episode here on Top Trending. If you did enjoy, don't forget to leave a like on this video.
Okay.
Hey, what is
Now let's see designs. What are designs? Let's discuss about it. डिजाइंस बेसिकली क्या होता है, जो आउटर शेप होता है किसी भी ऑब्जेक्ट का, उसका शेप हो गया या कॉन्फ़िगरेशन हो गया या कोई पैटर्न है, then ornament or composition of lines and color that are protected through designs. It can be 2-dimensional, 3-dimensional shape. ओके, जैसे कि यहाँ देख सकते हैं कोई साड़ी का जो पैटर्न है, जो डिज़ाइन है, that can be protected through design. The shape of a fan, the shape of inhaler or the shape of Coca-Cola bottle, these are protected by designs. So design basically represents the outer shape, the appearance of any object. And generally term of the design is 10 years and it is extendable to 15 years. जैसे यहाँ पे देख सकते हैं डिफरेंट शेप एंड कॉन्फ़िगरेशन एंड सरफेस पैटर्न है बोटल्स में. दीज आर ऑल प्रोटेक्टेड बाय डिजाइंस. And also the design of any automobile, any design of any shoes, design of table clock, alarm clock, table lamp, and the design of we have already discussed that the Apple MacBook, the design of that Apple MacBook that can be protected through design. The shape and the shape of Z Fold phones and flip phones of Samsung, these are also protected through designs. Now, what are trademarks? Trademark basically it's a sign that is that distinguishes from the goods of and services of one enterprise from another enterprise. The logo, it generally represents the logo. It's a sign. For example, the Adidas. The मान लीजिए कोई भी शूज में जैसे एडिडास का लोगो है, तो आप पहचान जाएंगे कि वो एडिडास कंपनी को बिलोंग करता है। वैसे भी कोई अगर पूमा का शर्ट पहना है, टी शर्ट पहना है, तो उसमें पूमा का लोगो होगा। नाइकी का शूज़ है तो उसमें नाइकी का साइन होगा। कोई बर्गर है, आप कैसे पहचानेंगे कि वो मैकडी का है, तो उसमें मैकडी का सिंबल होगा, लोगो होगा। कोई पिज़्ज़ा वो पिज़्ज़ा हट का है या डोमिनोज का है, उसको आप कैसे डिस्टिंग्विश करेंगे? उसमें जो साइन होगा, जो पिज़्ज़ा हट का जो सिंबल है और डोमिनोज का जो साइन है, उससे आप डिस्टिंग्विश कर सकते हैं। उसी तरह फेडेक्स, ब्लू डार्ट एंड इंडियन पोस्ट वो एंटरप्राइज को रिप्रेजेंट करता है। जो साइन एंटरप्राइज को रिप्रेजेंट करता है उसको आप ट्रेडमार्क के थ्रू प्रोटेक्ट कर सकते हैं। नाउ जनरली द सब्जेक्ट मैटर ऑफ ट्रेडमार्क्स आर ब्रांड नेम। ब्रांड नेम जैसे कि नाइकी हो गया, एलजी, कोको कोला, मैकडोनल्ड्स, केएफसी, लोरियल। सो इट रिप्रेजेंट्स ब्रांड नेम एंड एनी टैगलाइन. For example, in LG, it is life good, life's good. Nike, just do it. I am loving it. These are taglines, slogans that are attached to the brand name. These are that can be protected by trademarks. Also, the sound mark of lion roaring in MGM Britannia that are also protected by trademark, and the logo, the combination of color that is used in the logo here in Nike, all black, in LG, the colors that are present in Coca-Cola bottle, in MACD. So the combination of colors that is present in the logo, these are all protected by trademarks. So basically, trademarks represents the goods and service of enterprises. It distinguishes from one enterprises from another enterprises. Okay, and because of that, suppose if you have if you have a shoes, and there is another shoes which is written as Puma, another is written as any different spelling, Pumba, Pumba, suppose. Now there will be difference of price because one is original one which belongs to the original Puma company, and there will be difference of suppose one is 4,000, then another will be 400 or 500. Okay, so there is a need to protect and to distinguish one enterprise, the goods and service of one enterprise from another. And how to indicate your trademark? Trademark, when trademark application has been filed और वो रजिस्टर जब नहीं हुआ है, एप्लीकेशन फाइल हो चुका है, तो वो टीएम से प्रेजेंट होगा। जो लोगो जो सिंबल है उसके साइड में टीएम लिखा हुआ है। इसलिए क्या होगा, लिखा है वो एप्लीकेशन फाइल्ड है एंड रजिस्टर्ड हो चुका है, वो ट्रेडमार्क रजिस्टर्ड हो चुका है, इट इज रिप्रेजेंटेड थ्रू आर. नाउ लेट्स सी कॉपीराइट. कॉपीराइट्स क्या होता है? जो राइट्स जो we have discussed about the intellectual properties, different rights, patents, designs, trademarks. उस राइट से प्रोटेक्ट नहीं होता है, दैट कैन बी प्रोटेक्टेड थ्रू कॉपीराइट. जैसे कि कोई आर्टिस्टिक वर्क हो गया, कोई म्यूजिकल वर्क हो गया, या सिनेमेटोग्राफी फिल्म, एनी साउंड रिकॉर्डिंग, एनी फोटोग्राफ, any computer generated work. It can be also literary or dramatic work. These are protected by copyrights. So it's a bundle of right, and this right is an exclusive right given to the creator of the original work of authorship. And it, by protecting your any artistic work through copyright, आप क्या कर सकते हैं? कोई अगर आपको कॉपी कर रहा है, मान लीजिए कोई म्यूजिक आपने क्रिएट किया है, तो उसको आप कॉपीराइट से प्रोटेक्ट कर रहे हैं, और कोई दूसरा अगर कॉपी कर रहा है तो कॉपीराइट इन्फ्रिंजमेंट होता है. आप थ्रू कोर्ट उसको एनफोर्स करा सकते हैं. सो रजिस्ट्रेशन इज नॉट मैंडेटरी इन कॉपीराइट, एंड जनरली द कॉपीराइट कम्स इनटू एग्जिस्टेंस एज सून एज द इंटेलेक्चुअल वर्क इज क्रिएटेड. मगर आप उसको अगर एनफोर्स करना चाहते हैं, उसका जो राइट है आप उसका एंजॉय करना चाहते हैं, यू नीड टू register that, and through registration you can enforce when there is an infringement of copyright. Okay, so copyright generally includes literary works, paintings, photographs, drawings, films, musics, choreography, sculptures. So basically copyright क्या करता है? जो artistic work है उनको protect करता है. Okay, and the term of copyrights, generally the terms of copyright is in case of literary, dramatic, and musical or artistic work, it is the lifetime. During the lifetime of the author, and after that, after the death of the author, up to 60 years, the term will be there. Okay. And in case of anonymous or pseudonymous work, the term will be 60 years from the work that is been first published. In case of work of public undertaking and government work, also that will be 60 years. And work of international organization, it will be 60 years from the first publication. And sound recording and cinematograph films, also the term will be 60 years from when it was first published. Okay, what is the semiconductor integrated circuit layout design? Let's see. The semiconductor integrated circuits are fabricated from a series of layers of semiconductor, metals, and dielectric insulator. And the important thing is that it should be original, ये distinctive होना चाहिए, capable of being distinguishable from any other layout design, and have not been commercially exploited anywhere else. Then it will be protected through semiconductor integrated circuit layout design. Okay. It must be original, distinctive, capable of being distinguishable from any other layout designs, and it is all it's and have not been commercially exploited anywhere else. So these are the criteria for to protect through this intellectual property right. Now let's see what is geographical indication. Before moving to geographical indication, let's see one video. What is geographical indication is.
Europe and India, they have some common sort of ideas and thoughts, particularly protecting the traditional product, unique product.
India is certainly, like the European Union, an area of the world with a long history, millenary civilization, and this is a prerequisite, if you like, or certainly fertile ground for geographical indications to grow. You need to have tradition, you need to have art, you need to have culinary culture, if you like, for geographical indications to grow.
India enacted a specific law for protection of geographical indication rights. And then the first registration started with Darjeeling, and today the journey continued. We have more than 280 GI registered in India.
opportunity for those people who want to keep up with the tradition and maintain these the cultural roots by doing the same thing that their ancestors did. And for that, of course, you need to create a vehicle that allows these people to communicate with consumers.
You are giving unique product. It may be unique in terms of say nutritional value. It may be unique in terms of color, taste, attractiveness. You are giving good products to the international people, the global citizens.
India is part, an important ingredient, if you like, on any strategy to make intellectual property protection more effective on a sustainable basis around the world. So we need to focus a lot on sustainability. And what this project is about is generating things that we can touch a little bit today, but hopefully that we can touch maybe 3, 5, or 10 years down the line. Geographical indications represent a meeting point between Europe and India. It is an area where clearly there is a lot both we can share, and we are very happy about it.
Okay. So we have seen that geographical indication, basically it's a tag that is used, or it's a sign that is used to represent any product, and that product has a specific geographical origin, and that's due to that specific geographical origin, the qualities and reputation and characteristic that will be distinguishable from any other product. तो बेसिकली क्या होता है, कोई भी प्रोडक्ट मान लीजिए दार्जिलिंग टी है, एंड बिकॉज ऑफ दार्जिलिंग दार्जिलिंग ओनली एरिया द टी उसको उगाया जाता है, तो बिकॉज ऑफ दैट स्पेसिफिक जोग्राफिकल ओरिजिन उसका जो क्वालिटी होगा, उसका जो रेपुटेशन और कैरेक्टरिस्टिक होगा, इट विल बी यूनिक टू दैट. सो जोग्राफिकल इंडिकेशन and that is used, and geographical indication tag is used to specific product. Okay, and India has invented the geographical indication of goods act 1999, which came into force on September 15, 2003, and the Darjeeling tea was the first product to be tagged with geographical indication in 2004-2005. And 132 products including Bikaneri Bhujia from Rajasthan, Banarasi Sari ho gaya, and many more products has become geographical tagged up to September 2010. और जोग्राफिकल इंडिकेशन रिसेंटली क्या हुआ था, जैसे रसगुल्ला को लेके डिस्प्यूट हुआ था उड़ीसा और वेस्ट बंगाल में, और उड़ीसा वाले जो हैं क्लेम कर रहे थे कि उनका रसगुल्ला है, वेस्ट बंगाल बोल रहे थे कि उनका रसगुल्ला है. तो फाइनली उनको इसमें जो डिसीजन आया कि जोग्राफिकल इंडिकेशन दोनों को दिया गया. उड़ीसा वालों का उड़ीसा रसगुल्ला हुआ और वेस्ट बंगाल का बंगाल रसगुल्ला. एंड लेट्स सी अदर जोग्राफिकल इंडिकेशन, जैसे सोहारी कोहर पेंटिंग्स, एंड तेजपुर लीची, महाबलेश्वर स्ट्रॉबेरी, चंदेरी फैब्रिक, सिंधुदुर्ग रत्नागिरी कोकुम, मेहोर राइस, leather toys of Indore, bell metal wares of Dacia and Tikamgarh, Bach prints, Darjeeling tea, Kolhapur jaggery, Kodaikanal malai pondu, and wooden mask and Kusamandi, Nasik Valley wine, Nimala Kunta leather puppetry craft, Lucknowi Jardoji, Madhubani paintings, Surmala Hill banana, Alfonso from Konkan, Kashmiri saffron, Telia Rumal. So these are all geographical indication uh, that is used to represent the unique product of that, because of uh, the specific geographical origin. They have specific characteristic, they have unique qualities and reputation. Now let's see what are trade secrets. Trade secret is an practice or process of a company that is generally not known outside the company, and it is kept secret. And the information considered a trade secret gives the company an economic advantage over its competitor and is often a product of internal research and development. जैसे कि कोका कोला बनाने का जैसे फॉर्मूला है, it will be protected by trade secret. It's an agreement of confidentiality. जो गूगल का जो सर्च एल्गोरिदम है, that is also protected through trade secret. जो मैकडोनल्ड का बिग मैक स्पेशल सॉस है, जो इंग्रेडिएंट यूज किया जा रहा है, जो फॉर्मूले से बनाया जा रहा है उसको, दैट इज ऑल्सो प्रोटेक्टेड. KFC fried chicken also, the process they are making, it is an agreement of confidentiality. It is kept secret from outside and it is not known to the outside of the company. Now, what is plant variety protection? Plant varieties and animal breeds should be regarded as intellectual property of the breeders who have developed them. जनरली ऐसे आर्ग्यू किया जा सकता है कि कोई भी जैसे प्लांट है वो तो नेचुरली उगाया जाता है, इट्स नेचुरली ग्रोन, एंड इसमें इंटेलेक्चुअल प्रॉपर्टी कैसे प्रोटेक्ट कर सकते हैं. मगर ऐसा नहीं है. जैसे साइंटिस्ट अपने लैब में थ्रू कॉन्सिडरेबल रीऑर्गेनाइजेशन ऑफ एग्जिस्टिंग जीन कॉम्बिनेशन को चेंज करके स्किलफुल सिलेक्शन ऑफ वर्क, they develop different varieties of plants, okay, and that plant varieties that can be protected. The work of the scientist or the breeder who have developed them, that work will be protected through intellectual property right. In USA, the following three different system of protection are available. Generally, India में plant variety protection act, plant variety protection was not there, but ये यूएसए में पहले ये तीन सिस्टम थे, जो कि पहला था द प्लांट पेटेंट एक्ट 1930 which covers variety of asexually propagated crops, for example ornamental and fruit trees, and the second one is the plant variety protection act of 1970. इसका जो modified version है वो इंडिया में फॉलो किया जाता है. And the third one is the Utility Patent Act 1985 that was originally meant to cover man-made industrial invention and process. And we have seen that intellectual property is everywhere and there is need to protect those to earn economical benefit out of it and to commercialize it and to have enjoy the right throughout the duration, throughout the term of that intellectual property right. And let's see one video how we are surrounded with intellectual properties around us. Okay, let's see. the different intellectual property rights that we have discussed, what are the validity, what are the duration within which the inventor will enjoy the rights. For patent, it will be 20 years term, and the 20 years term that is generally counted from the date of filing of that patent. And there is nothing called global or international patent. Generally, we have discussed the limitation of time and limitation of space. The limitation of space here is that within the territory of the country in which it is filed, the patent, suppose you have filed any patent in India, then it will be valid throughout the territory of India. And there is nothing called global or international patent. And in case of design, the validity, the term will be 10 years and it can be extended up to 5 years more. In trademarks, it is indefinitely. Then geographical indication also indefinitely subject to the renewal. Okay. And in copyright, the term is lifetime of the author, and after the death of the author, up to 60 years. And who can apply? Generally, the person, it can be individual or through his legal representative, he can apply. Or that person include firms, partnership, small entity, any body corporate. Okay. And all the IP rights are territorial in nature. And these are some points to remember. First, when you have any invention, if you do any invention, first you need to protect what are the intellectual property that are associated with that invention. Okay. After protecting that, you publish. And these rights are territorial in nature. These are limited to the boundary of the country or sovereign authority in which that right is protected, that is granted. Okay. And registration is required here. In each country, you need to register these intellectual properties. Now, registration is done by the sovereign authority, that is the government of India do the registration. When you apply for protecting any intellectual property, government of India will do the registration. And the rights, for it will be rights for limited period of time, as we have already seen. And no automatic relief. You do not get any automatic relief when there is an infringement of, suppose you have a patent. Okay. Suppose you have a patent for any specific drug, and another company is copying your drug, and he is making it and he is selling in the market. Then you need to file an infringement suit. Okay. And without filing any infringement suit, you will not get any relief. And the next one is renewal fees is required to be paid from some intellectual property right. The renewal fees is required. And appointment of patent agent is not compulsory. And patent agents are the suppose any company is filing any patent, then it can file through patent agent. The patent agent can deal with all the patent procedures, dealing with the filing, dealing with the procedure in between till the grant, and after the grant also, the patent agents deal with the procedures of patent. And it's not compulsory, but that because any applicant can also sign the document, it can file the patent himself. Okay. And these are the contact details for further training. Rajiv Gandhi National Institute of Intellectual Property Management, situated in Nagpur. Okay, thank you. My presentation is complete, and my colleague Subrat Sahu will further discuss about the patent filing procedures. Okay. Okay, thank you so much.
Thank you, Avas. Thanks for such a nice presentation, and you really enlightened them about the importance of IPR, starting from patent, trademark, copyright, design, and all the aspect of the trade secret as well as farm right. So out of that, what I will do now, I will let you know how to file a patent, right? Before that, I will tell you how to write a specification. See, whenever you are filing any kind of patent, it is a procedure same like the what we are doing in our laboratory during the what do you call the writing a paper, right? Suppose somebody, some any research scholar or any faculty member or any student, he has done some work at the back end. Now the time has come to make them present throughout the world, right? So it is the same way. The way you are writing a paper, I will tell you how to write an patent application. See, patent application is nothing but a techno-legal document. 80% of your work is totally, you have to be documented in such a manner that it should be granted in Indian patent office or in other jurisdiction of any other country, right? So it is kind of art. The way you are writing your invention, the way you are presenting your work, so that the whatever the person who are just present in front of you or somebody who is examining your work, then he must be in a crystal clear that yes, he has or she has done somebody she has done something, and that is very good result I can expect, right? So I will let you know what are the document you need to get through, what are the document you need to prepare before filing a patent, what are the all those work you need to documented before filing a patent, and what is the procedure, whom to contact, what to file a patent, how much fee you have to pay, what are the form you need to file. All these aspect I will let you know one by one, right? Just give me 2 minutes. I will change my computer because it's not showing the sharing part here. So I will let you know how to filing a patent in other computer. Just give me 2 minutes.
Hmm. Hmm. Okay. Yes. Am I audible?
Audible, sir.
Am I audible, sir?
Audible, sir. Audible.
Hello.
Yes, sir, you are audible, sir.
Yes. Am I audible, right? Okay. So now I will tell you the patent procedure and its legal perspective. And then before starting, let me tell you what are the thing what is patentable. See, all the process and all the product which are new, which having an inventive step, and which is industrially applicable, and it is not barred under section 3 and section 4 of the patent act, that is patentable as per Indian Patent Act 1970, right? So if anybody who is working in any kind of lab and comes through a product or comes through a process, now he comes to me and, sir, is this patentable? Then I will see through the lens of these four criteria whether your product is totally new, that means it is not produced by anybody anywhere in the world. Mark my word, anywhere or anybody in the world, right? Now, whether it is involving any inventive step, I will let you know what is inventive step in the next presentation, right? And it must be capable of industrial application, means it must be able to produce a very large number in any kind of industry, and it should not be barred under section 3 and section 4 of the patent act. I will go through you what are the section 3 and section 4 of the Indian patent act one by one. Now I will tell you what is new. See, again, what is product? Product means any apparatus, any device, any machine, any chemical product, any drug or food or their compound, or any chemical composition or any biological product. These are the things that come under the product, right? Now I will tell you what is novelty. See, you can see there are six kind of bulb already is there, right? Somebody comes through here and say, I have an idea, and my idea is totally different from what is already there in the world or what is already there in the market. Then what I will do, I will choose my parameter to see whether that particular bulb he has invented is totally new or not, whether the idea which has just come through his mind is totally new or not. If I found out that through different databases, I search out that that particular idea is totally new, then I will say yes, your invention is having some kind of novelty, right? So novelty means in the very blind sense, you can say it's totally new to any kind of world, right? Now, what is inventive step? See, suppose a product is already there, right? And you have developed a new product. Then if you come to me and you see, sir, can it be patentable? Then I will check whether it is inventive or not. What is the inventive? See, whatever the product you have developed, it must be economically suitable to the product already there in the market. And there must be a technological advancement, means there must be efficiency. Suppose somebody has already developed a bulb, electric bulb, I will see whether that kind of bulb is already there in market. If I find out that yes, that bulb is already there, but you come to me and say, sir, that particular bulb is consuming more than 20% of energy, and my one is totally efficient one, he is not consuming anything, then I will say yes, he has done some technicality on that particular invention, and yes, it is feasible in this world, and it is economically important in our market that it is consuming less energy as compared to the previous one. If I find out that it is technically advanced and it is economically more advanced and economy more benefit as compared to the existing one, then I will say yes, it is inventive step, right? Now, industrial application, it is as simple as possible. You must it must be capable of made in any kind of industry in a very large manner, not in 10 to 20, very large manner, right? Now, this is the thing we must keep in mind before going to work in any kind of laboratory or in any kind of work. See, these kind of idea are not patentable under section 3 of Indian Patent Act 1970. See, whatever the invention or whatever the idea which is frivolous in nature, which is contrary to well established natural law, means somebody just comes to me and says, sir, I'm dropping my mobile phone and it moves upward. How it's possible? It's against the nature of gravity. So this kind of idea is not patentable. So whatever the idea you are giving, it should not be contrary to the well established of natural law, right? Anything that is contrary to morality or injurious to public health, that is, it is injurious to animal or plants or environment. This point generally creates a debate between genetically modified animal and genetically modified plant. That debate is still revolved throughout the world, most probably in the India. Still, we are in a confusing state whether the genetically modified organism is grantable or not. Because if somebody comes to me showing us the data, it is injurious to the plant variety or it is injurious to particular environment, then I will say it's not patentable under section 3J of Indian Patent Act, right? So you keep in mind, but some another person who comes to me and say, no sir, this data is not up to that mark, and I am showing this kind of data which are showing, no, these have nothing to deal with any kind of injurious or morality issue, then I can say yes, it is patentable. So the way you are designing your work, the way you are carry out your work, that's the most important, right? The next one, any scientific principle or any abstract theory, it is also non-patentable. So any next to the new property or use of a known substance means somebody have already developed a product. Now what you are doing, you are using that particular product and you are saying I have developed a new concept and this is patentable. No, see, this thing is already developed in the market and you are not adding anything extra. So until and unless you are not showing something significantly much more advantageous to the prior one, it's not patentable, right? So these are the kind of things which are falls under section 3 of the Indian Patent Act. Now, as you already gone through the patentability criteria, it must be new in nature, it must have an inventive step, it must be having capable of industrial application, and it should not fall under section 3 and section 4 of Indian Patent Act. We have discussed section 3, now we'll discuss section 4. What is section 4? See, if anybody who is working about any product which is involving any defense material, suppose you are working on a particular missile or atom bomb or any particular atomic material. See, it's against our Ministry of Defense. So we are not providing you until and unless you are not getting permission from our respective ministry, you are not granted patent. So that's debarred the section 4 of Indian Patent Act, right? Now, who can file? As my colleague Abbas already told you, either you alone or jointly. Suppose you 4 people who are working on a particular lab, okay, and you 4 are working on a particular technology. Now you 4 are eligible to file an Indian patent application in anywhere in throughout the jurisdiction of the Indian patent in Indian scenario, right? So who are the people who can file? By any person claiming to be true and first inventor, by any person being the assignee of that person, or by any legal representative of any diseased person. Then what is true and first inventor? Suppose you 4 people who are working under CB Raman University, right? So you are using the resources of the CB Raman University. So those people who are working on a particular technology, who have invented the technology, they are the true and the first inventor, right? And though you people are using the resources of the CB Raman University, now the CB Raman University become the applicant. They are the CB Raman University will not be not the inventor. CB Raman University will become the applicant. You people who have developed that particular technology, you become the true and the first inventor, right? So during filing an application, suppose CB Raman University wants to file an application, then it's mandatory for CB Raman University to mention in his application that person A, Dr. B, Dr. C, Dr. D are the true and first inventor who are invented this particular technology. And the CB Raman University would put a signature over there. Until and unless you are not getting the signature by the CB Raman University or its legal representative, you are not proceed you, right? So these are the people who can file the patent. Now, where to file a patent? Either you can file a patent physical form, or you can go through the e-filing procedure. See, what is the benefit of the e-filing procedure? Actually, we are giving 10% less fee. We are providing you, because we are encouraging you people to no need to go through patent office and just queue there and file all those documents in physical form. You just open an ID over there by clicking the comprehensive e-filing, and by putting your ID, having all those documents ready with you, keep the money keep the money in the digital format, having a digital signature with you, then you are totally ready. After that, open your account, upload all those documents, pay the required fee, whatever needed by the government office. Now you will get a provisional application number. That means you are totally completed your process. Now this is the e-filing portal. See, here you need to log in. You will providing you the username and password. After that, you are now capable of login through your own user ID and password, and Keep all those documents ready with you. Once you get logged in this portal, upload all those documents. Once you uploaded, pay the requisite fee. Now it's over for you. Now the owner shift to the Indian Patent Office. The next stage, we will do the examination and we will let you know whether your invention is patentable or not. Right? Now, what are the documents you need to have before filing the application? See, you must have form number 1. Just keep in mind or write it down. You people must have form number 1 with you, form 2 with you, form 3, form 5, form 9, form 18. These 6 most important form you must keep in mind. You must keep in ready before filing an application. Then what is form 1? See, form 1 is nothing but you need to provide what is your name, what is your address, who are the inventor, who had invented that particular idea or particular invention, and what is the title of your invention. You just put your signature with the address. Now form 1 is complete. Now come to form 2. Form 2 is nothing but the way you are writing a paper in your research publication or anywhere in. See, in form 2, you need to write. I will show you how form 1 and form 2 looks like. In form 2, what you need to mention, form 2, you need to provide the abstract, the way you are working, the main principle of your working nature, the material method, whatever you are needing for working that particular invention, the working example, whatever you people need, and all those data whatever you got through those experiment, you need to mention, right? So after mentioning everything, at the end you have to write 10 claims. This is the legal aspect of the form 2. Whatever the point, whatever the object you are claiming, we will examine on those aspects and we will say you whether that particular person is grantable or not. Suppose you have developed a small, let's say, let me give you an example. Suppose you have developed a pen, right? And in writing, you are saying that I am just invented a pen which is having a different kind of ball, right? So during writing, it's flow very smoothly, right? So in claim 1, you have to write I or we claim a pen having this kind of ball made up of stainless steel, which having this kind of ink with composition this and this, which flow very smoothly. So you are asking for a pen and asking for the nib of the pen and the ink throughout the where you are it's make you flow very smoothly. So you are not only asking the outer aspect, you are also asking for the inner aspect. That's why we are right. We are telling. I am telling you, writing a draft or drafting a patent application is why it is so important. Because you are getting what you are wanting. You are not getting what you are not wanting, right? So that's all we makes you in form 2. In form 3, suppose in form 3 I will let you know if you want to file any foreign application. Means suppose you filed that application in India and now you want to file that application in US or in vice versa. Suppose you have filed that particular application in US, now it's time for you to come that application to Indian scenario. Then in form 3 we'll ask you better to mention in which country or where you have already filed this idea. For the government purpose, we need to ask you have to file form 3, right? Now come to form 5. This is the most important file. Form 5. Why I am saying? Because as I told you the example, suppose you people are working under the CB Raman University, right? And you people have developed the idea. Though you are using the resource of the CB Raman University, CB Raman University is not the inventor. Yes, he is the applicant, but you people are the inventor. So in form 5, what the CB Raman University will do, he will put the signature by saying Professor A, Professor B, Professor C. These 3 professors have developed that particular idea, and I am just putting my signature and agree that these 3 people are the true and the first inventor, though I am the sole applicant, right? So that's why we need the form 5. Now come to form 9. Why we need form 9? Suppose you want to see in Indian patent scenario, we publish your application twice. Before grant of patent, we publish your application in our Indian patent journal. We used to publish that Indian patent journal on every Friday. throughout the year, right? So we are providing you two options for the publication, that before grant of patent and after grant of patent, right? So before grant of patent, actually we took 18 months to get your thing published in the Indian Patent Office. But if somebody comes to me and say, no sir, actually I want to publish my work very soon, then what I will say, or we will say, yes, there is a provision as per Indian Patent Act. We are providing you that provision. You can file Form 9, and within a month your work will be published in Indian Patent Journal. So not so without waiting for another 17 months, within a month you have your work will be published in Indian Patent Journal, right? So this is the Form 9. Now the most important, the last form is Form 18. Why we need Form 18? Until and unless your Form 18 is not filed, that is called the request of examination. Whatever the invention you have filed in Indian Patent Office will not get examined. Until and unless it's not get examined, your patent will not get rewarded, right? So you need to file Form 18. By any means, you need to file Form 18 along with these all form. Now I will tell you how form looks like. See, this is the Form 1. You can see in the first column itself, it is written the applicant. So you need to put the name of the applicant, CB Raman University, Chhattisgarh, right? Now in column 2, the inventor. Who are the inventor? Professor A, Professor B, Professor C. These are the inventor. These are their address, right? Now come to column number 3. In column number 3, you need to put the title of the inventor. Suppose somebody is working on a smoothless pen, right? Thus, I will provide a ink having that kind of pen who's working very smoothly. I must put a title on my work, on my idea. So I need to put that title on the column number 3. In column 4, you need to put the address of all those things. And now come to part number 9, which is most important. In part number 9, the inventor who have invented that idea, they need to put their signature. And they have to confirm that, yes, we are the true inventor, we have discovered or we have just invented that particular idea, right? Until and unless you are not getting your signature, we will not proceed your filing, right? Now, so these are the Form 1, it looks like. Now come to Form 2. See, in Form 2, as I told you, the way you are writing a paper, same thing. Everything, whatever you have developed in your laboratory, you need to put in a piece of paper and you file it in Form 2. But the way you are writing, the way you are drafting the Form 2 is totally different. See, granting a patent is an art. It's not only the technology you are providing, the way you are representing your idea to us, it's 60% work is done. If suppose somebody has very well go through all his idea and very thoroughly he presented his idea so that we can read it properly, so that we can grant without putting much more objection to you. That means 60 to 70% of work is totally done. If somebody he has done some get a tremendous amount of work in laboratory, but he is not able to represent in a very efficient manner, then it is become very difficult for him to get a patent, right? So just keep in mind, to drafting is much more important to get a patent, right? So in Form 2, I will tell you in Form 2 what are the things you need. Title of the invention, the name of the applicant. Here, who is the applicant? The CB Raman University is the applicant. His nationality, address. Now come to provisional application, provisional specification, and complete specification. In Form 2, we are providing you two kind of what is called provision. See, suppose somebody comes to me and says, sir, I have developed an idea, but I want to file an application form. Though I have developed an idea, I haven't developed its model. I haven't generated its any kind of data till now. But can I file a patent? Then the answer is yes, you can file a patent. But thing is that only you need to write it down your idea in a single piece of paper, and put it as a provisional application, so that you will get 12 months of time. Within 12 months of time, you just go through your idea, you carry out whatever the things you want to do in a laboratory, generate the data, after generating those data and those results, you again compile in a piece of paper, in let to have 10 to 20 piece of paper, compile it, and now within 12 months come to patent office or in the e-module, you just upload it. Once you uploaded the complete data, now it's called the complete specification, right? So why we are giving an provision for provisional application means in order to just protect your idea so that nobody else comes to market and take that idea and he can file the patent before you. So to protect your idea, protect your interest, your right, what we do, we just created a provisional application. And once you file a provisional application, within 12 months, you need to file the complete specification, right? Now come to column number 4. This is the most important in the description part. Description part means the way you are writing a paper, in paper what you are writing, the material method, the working example, the result discussion, the conclusion part. In the same way, in the description, you need to write down whatever work you have done in your lab, right? Now come to the legal aspect of your patent application. That is the claim part. The things you are claiming having the legal right in the claim part only, right? So the Indian Patent Act 1970 itself ensure that whatever the object you want to claim in your specification, you must put it down in the claim part. Until and unless you are not claiming those things, somebody else comes through you and that claim those part, and you can't infringe them and you can't stop them, right? So our own advice is to better whatever things you want in your idea or in your invention, that put in a very succinct manner in the claim part, right? After you chuck down the claim part, now the next one is the date and the signature. You put your date, put the signature over there, right? Now the last part, see, in paper publication, generally what we used to do, we first make an abstract, but in patent it's totally different. We put the abstract in the last part. Okay, after drawing we put the abstract. Now I will tell you how the other forms looks like, and again I will tell you how to write draft a patent application at the next part. How? So this is the form 18. See, once your application, once you are ready with your all the form 1, form 2, form 3, form 5, and all are ready, now the next step is file form 18 to get your things examined in Indian patent scenario. So this is the actual granting procedure, right? Which we just go through in our Indian Patent Office. See, suppose you are filing a patent application in any jurisdiction of Indian Patent Office. Suppose today you file an application, so we'll take 18 months. After 18 months, it will get published in Indian Patent Journal. After 18 months, what you will do, you just put form 18, that is the request for examination. If you are not putting form 18, you are not going to examine your application, right? So you need to put form 18 along with all the form. So after form 18, what we'll do, then now the ownership to Indian Patent Office. In Indian Patent Office, what we'll do, we'll check it out whether your idea is new by just searching throughout the world by different database, right? Once we search your idea through different database, then we find it out whether your idea is already published in somewhere else, in US or in Japan or in some China or in European country. Okay, if it is not at all, if it is not at all published anywhere, then we will say yes, it is totally novel. Suppose we find out that that particular invention is somewhere already published, then what we'll do, we'll chalk it out set of objection. We'll write it down set of objection and send back to you, and that set of objection is known as first examination report. In first examination report, we'll tell you, sir, your idea is already present in US market or in European country. So after you got those objections, now the owners again shift to you. What you will do, you will say that no sir, that idea which is already there in US, that is having different feature, but our idea whichever we have just apply for public a patent in Indian Patent Office is having different features and having different efficiency with different kind of advantages. Once you convince us, with those kind of data, we throw your reply, then we will grant you a patent, right? But though some people in Indian Patent Office, or since we are, if still you are not convinced with the data, then the next procedure what we'll do, will give you an date. That is the hearing date. On that hearing date, we'll tell you better to come through that date or come to face by face. Now it's happening through video conference, and you just let us know how your idea is totally new and having economic significance and having advantage as compared to other data which have been found out in other country, right? On that hearing, you people, what you need to do, you make a thorough presentation that, sir, these are my features, these feature having these kinds of advantages, and it is nowhere anywhere in the world, and whatever database you have cited and whatever document you have cited, this document doesn't have that kind of feature. And on that day, if we convince, then what we'll do, we'll grant you a patent, right? But still, if you are not convinced and you are not at all convinced, then what we'll do, we'll refuse it. So this is the whole concept, whole gamut of our Indian patent granting procedure, right? Now, come to opposition. See, why I am saying the opposition is much more important, because if you people are working in a laboratory, somebody comes to you and you just get through your idea before filing your application. He just went to Indian Patent Office and he filed your idea, and after publication you came to know that अरे ये तो मेरा idea था. How somebody else can take my idea? Now, if the patent is till now in process and not at all granted till now, now you people have the right to oppose that patent application by filing in Form 7, Form 7A, as per Indian Patent Act 25(1), subclause 25(1) of Indian Patent Act, known as the pre-grant opposition. Means you are opposing that particular application who have taken away your idea before granting. That's why we are saying the pre-grant opposition. Okay, but suppose till now the patent has been granted and till now you hadn't know anything about that. But when the patent comes to market and within a year you came to know that that particular product is my brainchild, how somebody has can taken that particular product, at that time also you can approach the Indian Patent Office and you can say, sir, that particular product I have developed in my laboratory, somebody else taken away my idea, so that kindly stop that particular patent. Then what we'll do, we'll just form a committee and we'll rigorously examine all those data, and if we find out that yes, that particular idea is yours, then we revoke that patent, and there is another process we also can initiate. We can give that patent under your name, right? So this is two kind of opposition. You have a right given by Indian Patent Act as per the provision 25(1) and 25(2) of Indian Patent 1970, provided by our constitution to safeguard your right? Now, that's all about the forms, whatever you need to have before filing an Indian patent, before filing an application in Indian patent scenario. Okay. Now comes to type of application. Many people say, sir, he is having a German application, German patent. He is having a US patent granted under his name. He is having a UK patent granted under his name. So, sir, what are the different kind of patent? As my colleague Abbas is already told you, there is no such world called the world patent. See, whatever the act we are providing you, that is the territorial in nature. Means it's only workable under the jurisdiction of the Indian territory only. So, in the same way, whatever the jurisdiction, whatever the act the US has applied, that act is only available to the particular jurisdiction, particular territory of US only. Suppose you have granted a patent in US country, right? Doesn't mean that same patent is available in India also. No. For that also you have to file a separate application in India and to make through that different process to grant your patent in India also. So what does it means that Suppose you have developed an idea. If you want to protect it in any country, then you have to file there. You get through that patent on that particular country, and that particular idea is protected on that particular country only, not in different country. For different country, you again go through different channel to grant that particular patent in different scenario and different country, right? So based on that idea, we have divided the patent application into three most important criteria: ordinary application, convention application, and the PCT national phase application. What is ordinary application? Means only you are the national of India. You want to only file the application in India only. You don't want to file anywhere in the outside the India. So it comes under the ordinary application, and that's guided by under section 9 and section 10 of Indian Patent Act. Now come to conventional application and the PCT national phase application. See, suppose somebody has developed an idea. If he or she wants to file an patent application both in US, India, China, and Japan, then what he will do? What he want to do? He want to process the application separately in different country. That means it will create a lot of workload under him. For India, you have to phase out all those set of document and different fee and go to Indian Patent Office, file that. For European country, he is having the different set of document required, different kind of payment system they are having, and he has to go to European country through the either online or through any other means and file there. So this make the process much more clumsy, right? To make this process into streamline, what the World Intellectual Property Organization did, he makes certain kind of arrangement. That arrangement is known as PCT National Phase Arrangement. Means they are providing a single channel, single window. Through single window, what we'll do, instead of filing different application of same idea in different country, file a single application and take that reference to different country and just process there with their different act and different jurisdiction. So no need to file different for same idea different application in all those countries. Just file a single application, process it through the national page application, and just make sure you need to grant it whether in US or UK or Japan or China. So what will happen? You are not only saving the time, you are also saving your energy, you are also saving the money, you are also saving all those things input you need to give to different country. So to streamline all those process, the national page application has been developed, right? Now to convention application. See, suppose I have developed a pen in India. I want to protect that pen in US also, right? Then what I will do, suppose today I have developed the pen, let's say 1st January 2022, and I file it out in India, and within a year, so let's say this pen is granted in India. Now what we'll do, I'll move to US, and I will in 2023 I will approach US, and in 2023 suppose I am going to file the same idea in US, then what I will find it out that somebody else he has filed it in a different manner. Then what will happen? Whatever the idea I have protected in India, it is having no value in US, because before filing my idea, somebody else has filed in US. So in order to protect that particular right, what we did, we have make a convention with, let's say, 120 country. We make a treaty in 1970 that is known as Paris Treaty or the Convention Treaty. What we did, we put all those 120 country in a single signatory, and we said, suppose if somebody else he comes to India, file a patent application, then the day he has filed that patent application will be valid in the convention country, means the other signatory country also. That means suppose the idea you protected today here, that also automatically protect also on that other country also on that particular day. Means to get the priority date set, to get the priority date in running, you will make that such kind of convention. That's why we'll say those kind of application as the convention application, right? Now, again come to ordinary application. Again, we divided that ordinary application into patent of addition and divisional application. What is patent of addition? Suppose you are working on an idea. After working on an idea, after filing the patent application, you come to know that you are getting different result, and that result also having different economic value in market. Then you can approach the Indian Patent Office. You can say, no sir, I have also, by the working of my main patent, I also get an additional idea whether it is patentable. Then we can say yes, under section 54 of Indian Patent Act you can file another application or the new idea, but the validity of your application will be starting from your parent application. The day you have applied the patent application, from that day onwards the validity will start. Means the 20 years start from your patent, the parent application. No doubt you will get a patent of addition also, but the validity will be starting from the date where you filed the parent application, right? That's all about patent of addition. Now come to divisional application. Suppose during the examination we came to know that your application having more than one idea, there is no unit of invention. Then what we'll say? We'll say, see, you are having number 2 to 3 number of invention. Then what you will do? You just put another application and you say, okay sir, I just divided my main idea into two parts. The first part is, as I already have applied in Indian Patent Office, this is the second part, again I am going to apply. Then we can say yes, under section 16 of the Indian Patent Act, we can say there is a provision of patent for division application, right? Now, the last part. Till now we have completed what is patent, what are the requirement of patent, what are the form we need to have with us before filing a patent, and what are the prospective, what are the procedure of the Indian Patent Office, how to go phase by phase. If somebody has taken up your idea, how to oppose that particular granting procedure, and what are different kind of application. Till now we have covered up. Now the most important thing, how to write a patent, how to draft a patent, right? Now let's go. See, as I told you, patent specification, the way you are writing is nothing but a techno-legal document. Then what is the techno-legal document? The technical part is whatever the data you are putting in your paper, whatever the result you just got from your experiment. These are all the technical part, right? You need to put in your paper. You need to put your specification whenever you are writing a patent. The main aspect, the legal aspect, is the legal part, is the claim part. Means that legal part you are getting the exclusive right. If somebody comes to market, he is just increasing your right. That means automatically he is increasing your claim. Then only you can say, sir, that particular person is infringing my idea, so kindly stop them. So at that time what we will do, we will check it out. Whatever the claim you have asking in the patent application, each point by point is infringed by that particular inventor is or not. If we find out that that particular inventor is specifically infringe your claim, then we can say yes, we can stop them. So this is the most important aspect, is the claim part, the legal aspect of your application. Now, as we discuss the provisional specification, complete specification, I will go through the most important part. Yes, complete specification. See, what are the thing actually we need to have during drafting a patent? You need to put the title of the invention, the name and address of the invention. I will show you. See, this is the form 2. This is the point where actual the writing of your invention started. See, here it was mentioned the vehicle. Vehicle is what? The title of the invention is given vehicle. And who is the applicant? Applicant is the Hero Motors, right? The Hero Motor is the applicant. So this is the starting phase of your writing. Now you need to mention the field of invention, means under which field you are working, whether you are working in mechanical engineering, whether you are working in any civil part, whether either you are working in chemistry or in drug part or in biomedical science. You need to mention the field of the invention. After field of invention, you need to write down what are the background of the invention. Means suppose your idea is somebody else already developed in the market or not. If somebody has already worked on that particular idea, what you add on that particular idea in your work, you need to mention. That's why we need a background of invention, right? Now after background of invention, you need to telling them the drawing in the very schematic way. You need to mention, sir, this is my idea and this is the part of drawing which generally work for, and this is having this kind of support in my description, right? After drawing part, you need to mention, you need to describe each and every part of your drawing or each and every part of your work through very clear and very succinct manner in the detailed description page, right? After description, the most and important part is the claim part. See, the Hero Motor, how he is writing that, he is writing a vehicle comprising a starter switch configured to generate a start switch signal and an internal combustion engine and then starter generator and a combustion facilitator. See, what he is asking for? He is asking for a vehicle. No doubt he is asking for a vehicle. But under this vehicle, he is asking for a switch who generate the start signal. He is asking for a combustion engine so that no the Honda motor or any other Bajaj motor can take away that particular right. He is asking for a starter generator. So see, the kind he has, the way he has written this kind of feature in his claim, so that once that particular claim get granted, nobody else can take away that right. You are getting my point? So this is the way, this is the art in way we are writing a claim. You are writing everything, but in a very succinct manner. Suppose in a blind, when he comes to you and says, sir, a vehicle having this kind of thing and this. So you are asking for vehicle, we just grant you. Okay, we are giving a vehicle, we grant you. But if the Bajaj company comes and he said a vehicle having a starter generator using for combustion facilitator, we also granted that particular thing because that particular two feature is not there in your patent. After you get through the market, you came to know, and again you approach us, sir, you grant us vehicle and you again grant us vehicle with these two feature, that particular person, this is the total infringement. Then we will say no, not at all, because you didn't put the starter generator and the combustion facilitator in your claim. The Bajaj motor puts everything in their claim. So he got the entire claim, entire right, not you are. So during drafting, you must have a mind, you must have a clear-cut mind to put all the technical feature which needed to generate the wealth of an idea in a market. It must be there in claim, right? After writing everything, after writing all those part of the claim, now you can put your signature. Once you put your signature, now we examine all those things. Once it gets examined, now it is granted. Now I will tell you how. Yes, see, in drawing, just make you sure. See, the different part he has just mentioned in a very numerical way. 108, 122, 118, 1110, the engine part 1112. So everything, whatever they wanted in their bike, they have mentioned. And all those features has been taken to claim, because the claim only getting the exclusive right, the legal right, right? So this has been granted, and I will tell you how looks like. See, this is how an patent granted certificate looks like, right? So this all about the procedure and the legal aspect of the Indian Patent Office and the patent procedure, patent filing. And now we'll take you through a quiz section. After that quiz section, we'll take you all those question, whatever you people have with you, and one by one we'll give you answer. Okay? Thank you.
So thank you so much, Subrat sir, Abha sir, for your excellent deliberation about patents, designs, trademarks, copyrights, and geographical indicators. It's really very wonderful session, and thank you so much for your observation about patent procedures and its legal perspective.
Thank you, ma'am. Thank you very much. Ma'am,
We are very,
ma'am first,
sir,
ma'am, I have one question.
sir,
Can the student can participate in the quiz section now? Are they able to answer?
Saurabh sir, can you please tell the answer? Saurabh sir.
Sir, they can answer you in the
Register,
chat
okay?
box.
Okay, 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 okay. Then I will ask my colleague, Mr. Abbas Kumar Bhai. Kindly first we complete the quiz section, then we'll take your question. We'll open for the question. Okay, sir. So Abbas, please come here. And you start your the quiz section.
So, screen. So let's start the quiz session. Am I audible?
Yes, sir.
Okay, that's one. So here, for the most famous trademarks, anybody can answer. The most famous present in this.
I will ask all the
Not able to
students
see the.
kindly write their answer in the chat box. Okay?
हमारे जितने भी पार्टिसिपेंट्स हैं, टीचर्स, स्टूडेंट्स, सभी से रिक्वेस्ट है कि वो इस क्विज का आंसर चैट बॉक्स में देते जाएं.
Abbas sir,
Awaz, sir? Yes.
Yes, yes, yes.
Yes, actually, your screen is not visible. Right now, it is visible. It's okay.
Okay. But actually, I'm not able to see the chat box. How will I see the answers? I'm not sure. If I make it full screen, then the chat box is not appearing in my screen.
Sir, you can
Okay.
minimize the screen,
So I would.
minimize the entire window, and you can see that screen.
If I'm minimizing, then okay. So I will ask the question, and my colleague Subrat Sahu will assist with the answer. So, anybody can answer here what famous trademark present in this?
Abha, sir, it will be better if we come to the full screen mode because the screen is not at all visible properly.
It's not. Is it visible?
Yes, sir, visible, sir.
So what are the famous trademark here? One can other trademarks which represents enterprises, different enterprises. Is here. Anybody can answer.
Yes, TCS, Nike, Pepsi. Yes, yes, yes. Very good, very good.
Mic down also. Mic. Turn off the mic. So student have answered any question? I'm not able to see actually here. Shall we move to next question? So here different famous trademarks are Pepsi, Cadbury, Link, Horlicks, Babool, Bata, Tata, Lux, Dettol, Amul. The next question is find the intellectual properties in first picture. Anybody can answer. It's a painting. So through which intellectual property it can be protected? Slide is visible.
Yes, sir, visible, sir.
Okay. So the first one is painting. I'm giving you the answer. So it represents an artistic work. So artistic work generally हम protect करते हैं through copyright. And second one is and design shape sculpture. It's also agents and it will through copyright. One, the Apple logo that will be protected through trademark. The design of Apple MacBook, the iPhones, The designs will be protected through designs, the shape of the Apple MacBook and phones, and the technology involved in the display of Apple laptop will be protected through patents. And fourth one is business secretary. Fourth secretary will be protected through trademark because it Coca-Cola. The shape of a Coca-Cola bottle, it will be protected through design, and Coca-Cola that will be protected through a trademark. Now, which type of intellectual property protects the painting painted by artist? If anybody can answer,
Copyright.
yes, correct. Because painting are artistic works, so it will be protected by copyright. Good answer. Next one. What protects the intellectual property created by fashion designers?
Registered designs, I think.
Yeah, registered designs and copyright, both.
Copyright.
The designs of the work is created by the fashion designer will be protected through registered designs, and as it is a artistic work, it is protected through copyright also. Now, what protects the advanced disc brake for bike developed by the inventors? Answer. Okay, the answer
Patents.
is yeah, correct. Patents, because patents protects technological advancement. Okay, so here the advanced bike disc brake that is used in the bike will be protected through patents. And which of these is a geographical indication? So the answer is Pathani Sari,
And I'm sorry.
because it relates to specific geographical origin, and because of that specific geographical origin, it has specific qualities, unique characteristic out of. Now, what does a trademark protect?
Logos, names, and brands.
Yes, correct. Trademark protects logos, names, and brands. They basically represents an enterprise. They distinguish goods and service of one enterprise from another. And how long do patents usually last for? The term of patents.
10 years?
Arvind Tiwari.
20 years.
10 or 20
Yeah,
years.
20
20.
years. Very good answer. Now, if you write an original story, what type of intellectual property gives you the right to decide who can make and sell copies of your work?
Copyright, I think.
Yes, correct. Very nice. It will be protected through copyright because it's a artistic work. Now, imagine a cricketer sets up his own company to sell his own range of clothes. What type of intellectual property can he use to show that the clothes are made by his company?
Trademarks,
Yeah, trademarks. One answer is
registered
trademark.
design.
Yeah, second one is registered design. Very good answer. Because through trademark, the logo or sign that will represent his company, and through registered design, he will protect the design of the clothes.
Designs.
Okay, so very good answer. Now, if a company develops a new technology that improves its main product, what type of intellectual property can they use to stop others from copying their invention?
Patents and copyright, both the thing I think.
Basically,
Drawings,
it's
design.
Patents,
yeah,
তারপরে
the company is
pet-
developing new technology,
Patents.
so it will be the right answer will be patents.
Patents.
Yeah. And yeah, thank you so much for listening very carefully, and as you have answered all the questions very nicely. Thank you so much.
So thank you so much, sir. We are very grateful to you to sharing your expertise with us in this time. Thank you so much once again. So now, in this August gathering of workshop, we have respected Professor R.P. Dubeji to deliver the concluding remarks and presidential speech of today's workshop. Professor Dubeji, over to you, sir.
Okay, thank you. Am I audible, madam?
Audible, sir. Audible.
Okay. Thank you. So, uh, good afternoon to all. नमस्कार आप सभी को. So, as you know that today IQVC of CBRU and IPR Department of Commerce and Industry, Government of India, jointly organized this very important workshop on intellectual property rights and patents, design and process. Uh, and today's experts, as you well listen, Shri Subra Sahuji, respected Sri Subra Sahuji, and second one, respected Sri Bhash Kumar Bhoiji. Both are from Ministry of Commerce and Industry, Government of India. Uh, and we have also our Pro VC, respected Jati ma'am, respected Registrar Gaurav Shukla ji, respected Dean Academic Tiwari ji, respected Dean Welfare Upadhyay ji, Professor Anupam Tiwari ji, uh, uh, Dr. Uh, Saurabh Mitra ji, uh, all faculty members, uh, especially Dr. Jyoti Bala, anchor of today's workshop, and all faculty members, scholars, and students of and all participants joined this through YouTube and other electronic media. Uh, so first of all, I congratulate to organizers and welcome to all participants and all dignitaries in this workshop. Uh, as you know, our registrar explained about the uh, university and what are activities done by our scholars and student faculties. Uh, I think this topic, today workshop topic is very important and useful for our all faculty members, scholars. जैसा कि रजिस्ट्रार साहब ने बताया कि विश्वविद्यालय ने 69 पेटेंट्स कराए हैं अभी तक. So it is a big achievements of our scholars and teachers. Uh, आज जिस तरह से दोनों एक्सपर्ट्स ने पेटेंटिंग के बारे में, कॉपीराइट्स के बारे में, लाइसेंसिंग के बारे में अपने प्रेजेंटेशंस में बताया, मैं समझता हूँ कि यह हम सबके लिए बहुत ही यूजफुल है, इम्पोर्टेंट है, क्योंकि जैसा आप समझते हैं कि अपने देश में बहुत समय तक ये जो शब्द हैं, ये जो केवल आईआईटीज और एनआईटी तक सीमित थे, लेकिन आज जो स्थिति है, देश के एक छोटे से दूर दराज के जो गांव में जो कॉलेज हैं, वहाँ भी के जो टीचर हैं, वहाँ के जो विद्यार्थी हैं, वो इन शब्दों को, इनके बारे में समझते हैं और बहुत तेजी से जो है वो इस दिशा में काम कर रहे हैं. और मैं समझता हूँ कि इस वर्कशॉप से और भी इससे गति मिलेगी और खासकर के जो हमारे विश्वविद्यालय के जो स्कॉलर्स हैं, स्टूडेंट्स जो आज इसमें जुड़े, शामिल हुए, उनके बहुत से जो प्रश्न थे वो आज जो है उनके जवाब मिले होंगे. और मैं तो यही कहूँगा कि जिस तरह से आज पूरी दुनिया में एक सारा कुछ जो है कमर्शलाइज होते जा रहा है और सारी जो व्यवस्थाएं हैं उन पे जो है हमें सचेत रहना चाहिए, क्योंकि अगर आप देखें कि आज जो पूरी दुनिया में जो जितने भी इन्वेंशन हुए, उनमें अगर हम अगर उन्हें सही ढंग से आंकने लगे तो आप पाएंगे कि जो हमारे वैदिक साइंस में जो काम किया, वही आगे चल के जो मॉडर्न साइंटिस्ट और मॉडर्न जो टेक्नोलॉजी में वो पेटेंट के रूप में रजिस्टर्ड हुए. तो ये जो कार्य है वो बहुत तेजी से होना चाहिए और मुझे बहुत खुशी है कि आज गवर्नमेंट ऑफ इंडिया के दो एक्सपर्ट्स, जिन्होंने बहुत अच्छे तरीके से और काफ़ी विस्तार से हर एस्पेक्ट को छुआ है और इसके बारे में विस्तृत जानकारी हम सबको दी है. मैं विश्वविद्यालय की ओर से आप दोनों का हृदय से आभार व्यक्त करता हूँ एवं सभी जो आज ये वर्कशॉप में जुड़े पार्टिसिपेंट्स, उन्हें भी धन्यवाद देता हूँ और आशा करता हूँ कि हम तेजी से अपने बीच इस मुहिम को चलाएंगे और कॉपीराइट, पेटेंट्स, लाइसेंसिंग, रजिस्ट्रेशन के बारे में सारे जो हमारे विद्यार्थी हैं, स्कॉलर्स हैं, टीचर्स हैं, उन्हें अवेयर करेंगे. आपका बहुत बहुत धन्यवाद. थैंक यू.
Thank you so much, sir, for your valuable observation and inspiring address. Thank you so much. Now, I would like to request Dr. Anupam Tiwari ji, organizing secretary of this workshop, to extend the vote of thanks to all our delegates.
थैंक यू मैडम. आज डॉक्टर सीवी रमन विश्वविद्यालय करगी रोड कोटा बिलासपुर द्वारा आयोजित इस जागरूकता कार्यक्रम जो बौद्धिक संपदा अधिकार पर आयोजित था, इस जागरूकता कार्यक्रम में सबसे पहले सर्वप्रथम मैं इस कार्यक्रम में विशेष वक्ता के रूप में और विषय विशेषज्ञ के रूप में हमारे बीच जो इंडियन जो पेटेंट ऑर्गेनाइजेशन है, उनके जो एग्जामिनर ऑफ पेटेंट एंड डिज़ाइन इंडियन पेटेंट ऑफिस के श्री सुब्रत साहू जी एवं श्री आभाष कुमार भोई जी, दोनों विषय विशेषज्ञों को मैं विशेष रूप से धन्यवाद ज्ञापित करता हूं पूरे विश्वविद्यालय परिवार की ओर से कि उनके द्वारा आईपीआर के पूरे तकनीकी पहलुओं पर प्रकाश डाला गया. निश्चित रूप से इस कार्यशाला के पहले हम आईपीआर को बहुत अच्छे से नहीं जानते थे, बौद्धिक संपदा अधिकार के क्या होता है, और उसको विस्तारित रूप से जानकारी आप लोगों ने हमें प्रदान की और बहुत संक्षिप्त समय में यह आयोजन हुआ। और इस आयोजन को आपने हमें पूरी तकनीकी पहलुओं को अवगत कराया। इसके लिए मैं पूरे विश्वविद्यालय परिवार की ओर से आप दोनों विषय विशेषज्ञों का विशेष रूप से आभार करता हूँ। साथ ही इस पूरे कार्यक्रम के प्रेरणा रहे हमारे माननीय कुलपति जी प्रोफेसर आरपी दुबे सर का भी मैं हृदय से आभार व्यक्त करता हूँ। साथ ही इस कार्यक्रम में सतत मार्गदर्शन के लिए आदरणीय कुल सचिव श्री गौरव शुक्ला जी का भी मैं हृदय से आभार व्यक्त करता हूँ। साथ ही हमारे वरिष्ठ डीन एकेडमिक आदरणीय डॉक्टर अरविंद तिवारी सर का भी मैं हृदय से आभार व्यक्त करता हूँ। साथ ही इस पूरे कार्यक्रम को सतत रूप से मार्गदर्शन प्रदान करने के लिए इस कार्यक्रम में उपस्थित माननीय समकुलपति महोदया प्रोफेसर जयती मित्रा मैडम का भी मैं हृदय से आभार व्यक्त करता हूँ। एवं इस कार्यक्रम के संयोजक हमारे अग्रज आदरणीय डॉक्टर मनीष उपाध्याय सर का भी मैं हृदय से आभार व्यक्त करता हूँ कि इस पूरे कार्यक्रम को उन्होंने सभी से समन्वय स्थापित कर उनको सफल बनाने में अपनी अग्रणी भूमिका बनाई। साथ ही कार्यक्रम के सफल संचालन हेतु मैं ज्योति बाला गुप्ता मैडम का भी हृदय से आभार व्यक्त करता हूं और तकनीकी रूप से संचालन के लिए मैं श्री सौरभ मित्रा सर का भी हृदय से आभार व्यक्त करता हूं। इस कार्यक्रम में उपस्थित सभी छात्र छात्राओं और जो और भी विशेषज्ञ जो आउटसाइड से जुड़े उनका भी इस कार्यक्रम को सफल बनाने के लिए मैं हृदय से आभार व्यक्त करते हुए माननीय कुलपति जी के अनुमति से इस कार्यक्रम के समापन की घोषणा करता हूँ। थैंक यू।
सबको नमस्कार।
Thank you, sir.
Thank you so much, sir.
Thank you,
Thank you,
Subrat
Subrat sir.
Thank you, Abbas sir.
थैंक यू सर।
Thank you, Awaz sir.
Thank you, Subrat sir and Bhoi sir. Thank you very much.
Thank you, sir. Thank you very much.
Thank you,
Thank you.
everyone.
So we will stop now.
जी।